Hello friends, in the series on the income tax cases, today we will discuss a case on section 148 proceedings. And the issue before Delhi High Court was that whether it is sufficient for the assessing officer to issue notice under section 148 if the income has escaped assessment, where the assessment of the assessee has already been completed under section 143 subsection 3 4 years back. There is no doubt that whenever there are reasons that income has escaped assessment, the assessing officer can issue the notice under section 148 within the time frame, but there is a proviso to section 147 which casts a very special burden on the assessing officer to establish that the assessee has failed to disclose truly and fully the material facts which were necessary to complete the assessment. This is a classic case by Honorable Delhi High Court. The name of the case is Discovery Communications India versus Additional Commissioner of Income Tax, and this case is reported in 473 ITR at page number 627. And the date of judgment is 8th November 2024. In the present case, notice under section 148 was issued to the assessee for the assessment year 11-12, and the basis for issuing the notice to the assessee was that the assessment for some other assessment year has been completed, and on the basis of that assessment year, the assessing officer made the reason that the income of the assessee has also escaped for the assessment year 11-12, and in the reasons it was mentioned that it was the mistake of the assessing officer which resulted in under assessment of income, and the notice was issued to assessee under section 148 where the assessment of the assessee was already completed under section 143 subsection 3 before 4 years. The assessee challenged this notice on the ground that this notice is not as per the jurisdiction of the first proviso to section 147 because the reason do not spell the failure on the part of the assessee to disclose truly and fully all the material facts in the original assessment which was completed by the assessing officer under section 143 subsection 3 4 years back. When this writ petition was heard by Delhi High Court said that escapement of income is not the sufficient ground for reopening the case of the assessee where the first proviso to section 147 is attracted. Now the question arises, what is first proviso to section 147? The first proviso to section 147 says that if the assessing officer wants to reopen the assessment of the assessee which has already been completed by the assessing officer 4 years back, then the assessing officer has to cross a hurdle and has to spell in the reasons that the assessee has failed to truly and fully disclose all the material facts which were necessary for completing the assessment. Now the question arises that what does this abbreviation means? The court said that the reasons recorded by the assessing officer must lead to clear and direct inference that there was a failure on the part of the assessee to disclose truly and fully all the material facts which were necessary for completing the assessment. The court further said that the reasons must disclose that which material facts which were necessary for completing the assessment which were not disclosed by the assessee. The court said that the assessment of the assessee cannot be reopened on the basis of the change of opinion without disclosing that what material facts were not disclosed by the assessee on the original assessment completed under section 143 subsection 3 4 year backs. The court further said that the existence of failure on the part of the assessee shows not only the integral to the reasons but it should also be spelled in the reasons as what was to be disclosed and what was not disclosed by the assessee. Friends, the court further said that the absence of this allegation on the assessee in the reasons makes the whole assessment negatory. The assessing officer did not attribute that under assessment to any failure of the assessee, and the court said that it is not a procedural irregularity but it goes to the root of the matter. The court further said that the assessee cannot be allowed to suffer because of the mistake of the assessee, because in the reasons it was said that due to the mistake of the assessing officer there was under assessment of income. So friends, this is a very important case because it has been seen that the revenue is issuing the notices under section 148 like nothing, even for those assessment years for which the assessment has been completed 4 years back under section 143 subsection 3. This is a big safeguard to the assessee, and the case gives a very clear and loud message that the assessing officer has to spell even that what was not disclosed by the assessee and what was to be disclosed by the assessee in the original assessment. At the end of this video, once again, I am repeating the name of the case. The name of the case is Discovery Communications India versus Additional Commissioner of Income Tax, and this case is reported in 473 ITR at page number 627, and the matter has been decided by Honorable Delhi High Court on 8th November 2024. Thank you, friends.